Hi, all, and welcome to How to Comply with Trump's Executive Order Ending Illegal Discrimination and Restoring Merit-Based Opportunity. Believe me, Sarah and I did not come up with that name. It's very, very long, but it reflects essentially what we're going to talk about today. Again, my name is Nichole Atallah. I chair the Labor and Employment Practice Group here at PilieroMazza, and I will let Sarah introduce herself.
And I'm Sarah Nash. I work alongside Nichole, and we have been dealing with a lot of questions over the last few weeks that have been coming in about this topic. Generally, we handle, labor and employment matters. You'll see that OFCCP is listed on my bio there. That is another topic we will talk about today, Office of Federal Contract Compliance Programs and where they are in all of this. So excited to get going.
Yeah, so PilieroMazza, if you're not familiar with us, and many of you are, we're a full-service business law firm to government contractors, primarily small businesses. So in addition to, labor and traditional labor and employment, Sarah and I also do a lot of government contracting type work as it dovetails with our practice, which is why today's agenda is particularly important to our clientele and you because you're on the webinar. So we're going to talk about today. Well, there's a lot of activity. There's a lot of executive orders, right? Today is going to be limited to 14173, 14168, and 14151. And we're going to walk through each of these because I think there is a lot of confusion about what goes to what and what obligations apply to who and how it's being applied. And I don't think that confusion is just limited to contractors from what I've seen. I think there's also a lot of confusion internally about what applies to what. We're also going to talk about some common kind of questions and myths that we get, right? And we'll walk through our thoughts on, they're technically myths? How should we be handling some of this perception issues? We're going to walk through those. And those are primarily derived from questions that we've been getting over the last couple of weeks. And then we'll go through some best practices, how to really implement this stuff, how to decipher it and figure out what you need to do internally. Okay, so let's talk about the first executive order. This is one of the bigger ones where we have definitive things that you can be doing as contractors right now, right? And the principal thing that this particular executive order did was revoke the old executive order 11246 and associated executive orders. 11246 has been around since the Johnson administration. It's been around for a really long time. And it was one of the initial civil rights, executive orders and regulations, right? It told contractors that they needed to take equal employment opportunity with respect to, race, gender, national origin. During the Obama administration, we also added sexual orientation and gender identity to that. And so what the Trump administration did initially was just say, we're not doing that anymore, right? And involved in all of the regulations that are associated with OFCCP and EEO 11246, what we're seeing is that we're clawing back everything associated with 11246. So one of the points of confusion is, what does that mean for us as contractors, right, Sarah? And how should we handle that? Like, what do we do now? Do we take everything out? What does all this stuff mean? And we have some indication of what this means in an OMB memo, but Sarah, kind of what are you advising clients with respect to revocation of 11246?
Right. So, part of the problem with this executive order, which is sort of evident from its name in and of itself, right, is it's very vague. And we'll talk a little bit about how that's gotten it into some hot water with the courts. And there was an injunction last week. We'll get there. But one of the things that clearly is still in place is the revocation of this executive order from the Johnson administration. And that executive order did a few things, right? It created the Office of Federal Contract Compliance and Programs, OFCCP. So a lot of the enforcement mechanisms that go hand in hand with evaluating EEO practices have been restricted under Trump's administration's order. And it also created an obligation for contractors with certain threshold numbers of employees, so at least 50 employees and at least this number of contract dollars, they had an obligation to create affirmative action plans for their workforce for women and minorities. That obligation has been revoked by the Trump administration. So this executive order and nothing in the court's decision changes the fact that there's no longer an obligation for contractors to participate in these AAPs. And these were annual obligations that evaluated the numbers of employees that you had, looked at their race, looked at their gender or their sex, and based on basically the census, evaluated whether you were keeping up with numbers in the area. So, for example, if you had a certain labor classification, let's say secretarial workers, and 50% of your workforce was women, but the census showed that other similar businesses maybe had different percentages, there were generally goals that you were supposed to establish to get towards those numbers. And the Trump administration has taken the approach that those affirmative action plans are unlawful, DEI and not permissible. And so they stripped Executive Order 11246, and it's no longer an obligation. So that's, at least with respect to taking away that piece, that's what we're talking about.
Yeah, and there are also some downstream impacts of that, right? So we are starting to see FAR deviations that are removing the EO 11246 provisions. That also applies to subcontractors, right? So 11246 required all subcontracts to have specific language relating to, taking equal employment opportunity for, women and minorities, sexual orientation, gender identity. Those are going to have to come out of your subcontracts. So there are some things that you kind of are related to 11246 that kind of need to start coming out of you need to start looking at those documents and determining what needs to happen there.
Yeah, and I'll just add that there's nothing that doesn't mean you want to strip your handbook of your equal opportunity provisions, right? It just means that those FAR clauses no longer apply, and we're still sort of figuring out how the agency is looking at the way that you communicate your equal opportunity position and your policies.
Yeah, I mean, Title VII still exists, right? So that's what we're telling people,
Yes, we have a slide. We have a slide that shows you.
We have a slide on that, so hold tight. I'm just speaking to the specific language in your subcontractors that relates to this executive order, your affirmative action plan language that you might have a policy on. And we have these summarized on a later slide. It also prohibited contractors from taking, it really targets this idea of unlawful discrimination or anything that is, where you're motivated by a protected characteristic, and making sure that contractors and private entities even had directed the AGs to start investigating private companies that they thought maintained these illegal DEI programs. But it really didn't define illegal DEI. So a partial injunction was issued, and we've got the case site down here last Thursday evening. And it's kind of supposed to be pausing some of this, right, including the AG's investigation of private companies. And we'll talk about this certification language later. We do have a question that says, is there a requirement to submit an EEO1 report anymore? That depends. So EEO1 reports for government contractors were set at a 50 employee threshold. So if you had 50 employees, you had to submit an EEO1. All companies, commercial companies as well, have to submit an EEO1 over 100 employees. So you're still going to submit an EEO1 if you have over 100 employees. You're still going to need to know your employee demographics for purposes of completing that report. All right, I'm going to drive us. Anything else?
One more thing.
Yeah.
For this slide, yeah, it's just the OMB memo that came out gave us a little bit more clarity on what the scope of DEI that's limited. So I just want to make clear, and I think we have a myth about this, but it's not all DEI, right? It's just illegal DEI. Part of the problem is nobody really knows what that means. It's just sort of this amorphous, I'll know it when the agency sees it. But OMB did issue a memo that sort of explains some of the definitions within that. So it applies to taking action that's motivated in whole or in part by protected characteristics. So those are the typical race, sex, religion, national origin, things that you think about. And they also clarify it does not apply to affinity groups. So affinity groups still permissible. It does not apply to your EEO policies. It's really supposed to be targeting the hiring practices that focus on, preferences based on certain races, genders, you name it. And so that gives us a little bit of clarity, but still not quite enough. And again, that's part of why the injunction was issued. Just, it's really hard. We've seen a lot of contractors shying away from do I have to get rid of my my equal employment opportunity provisions in my handbook? And the answer is no, don't do it. Don't get rid of it. You need those, especially now.
Yeah, absolutely true. The other thing I'll just say is it's nice that OMB has a memo, but again, confusion persists. We'll talk about that. So even though there's this partial injunction, and even though we have this OMB memo, we've still seen this EO used to cancel contracts and try to force contractors into certifying, even though that we think that's impermissible under the partial injunction. There's a lot of confusion. Not everyone is on the same page and is swimming in the same lane. So I would use some of what we're telling you today. If you are a contractor that's running into issues with a contract cancellation or something like that, use this as a way to push back if you need to, but understand that there's still a lot of confusion out there.
We got another question just asking, what is an affinity group? So an affinity group, excellent question. Basically, it's a group that focuses on a certain type of issue. So for example, you might have a women's affinity group that focuses on women's issues, women's concerns, totally permissible. You want to make sure that anyone can participate in that group, and you want to make sure you're not excluding certain employees, but those types of sort of shared common interests are still permissible.
Yep. Which makes sense, as long as that, you're not giving special treatment to a particular affinity group, right, with respect to terms and conditions of employment. So even though the contractor certifications have been enjoined for now, and we wanted to show you what we've seen as far as, possible language that's been circulated by certain agencies. And I know, Sarah, you've seen this quite a bit. I have my own concerns about its impact, but if you notice, if this comes back online, it may require contractors as a material to payment by the government to certify that they are compliant, and I should have bolded this, in all respects with all applicable federal anti-discrimination laws. So my concern about this language, if you need to articulate concerns to anybody, and again, this has been enjoined. They're not, no one is supposed to make you sign anything right now. But if they come out with this type of certification language, I think it's going to open the floodgates on False Claims Act litigation. Because if you have to certify that you're compliant in all respects, and then you fail to accommodate someone correctly, or you don't investigate something promptly, that could be considered a violation of a federal anti-discrimination law. And now that plaintiff's attorney has a False Claims Act claim too. So I think it's actually going to make it more imperative than ever that we're focused on compliance with these laws.
Mm-hmm. Had a couple of questions, Nichole, pop in. One relates to questions about what types of contracts have been terminated under this particular EO 14173.
I've seen all sorts of that. I mean, anecdotally from people within the government who have said, hey, one example was someone who, someone from a government agency found a social media post talking about racial equity and terminated a contract on the basis of that. So we are seeing it anecdotally. There's a number of contracts that we've seen canceled where there's no explanation at all for the termination. Nobody really knows why it's been terminated. But we know that agencies and the DOJ are watching and using AI to look at this. So even though I could tell you they're not supposed to be terminating contracts on the basis of, this certification, and frankly, you're supposed to have 90 days to implement this anyway, we're seeing it happen. So just keep that in mind and make sure you call counsel. There are some things that can be done. They're not immediate, but, any way that you can push back and try to figure out why contracts are being terminated. If it's on this basis, that's technically impermissible. It doesn't mean we're going to be able to get the contract back for you tomorrow, but it means you may have access to more damages than you might otherwise have for just a regular termination for convenience. So just something to kind of keep in mind and keep educating about. I know that I had to educate people in my own household about, hey, does the Office of General Counsel at this agency know that this injunction came down on Thursday night? And folks didn't know there, right? So you have to keep educating folks and keep, sharing information, because it's just so much information out there. It's hard to keep up with everything.
Mm-hmm. And this does not apply to Native American preference hiring. That's a carve out. It's statutory. We'll talk about some other exceptions. Generally, an executive order can't contravene the statute. And so there are some limits. It doesn't mean that the administration or agencies haven't tried to do it anyway. That's kind of a separate issue. But for the time being, this executive order has nothing to do with the Native American preference hiring.
Although if you are applying Native American preference, make sure you understand the rules. It's not unlimited. It's actually very limited. So if you're using that, make sure you understand the parameters there. Because that, I think, could get you into trouble, right? Like if you were not, Native American preference hiring, you have to comply with those rules. And if you're not compliant with those rules, then I think you could get into some discriminatory hiring issues. So maybe outside the scope of a particular webinar. Okay. Sarah, you want to dive in here?
Yeah, not to intimidate anyone or make anyone feel sad about how many laws are out there, but there are quite a few federal laws that apply to employment practices generally, terms and conditions of employment. These all are still in play. And arguably, you saw those certifications on the prior slide. These are even more important now that we have certifications, because basically, assuming that this injunction gets lifted or agencies are allowed to continue with these certifications, there is a representation that contractors will not engage in conduct or policies that are violative of anti-discrimination laws. And so this is just a list of what those laws are that are still in place. Like I said, we've gotten a lot of questions. Should I get rid of my Title VII protections? No. Should I stop investigating allegations of harassment, or should I stop granting ADA accommodations? No, those are all statutory requirements that are still here, and arguably these certifications require even more so that you are compliant as government contractors. So this is just a list. You'll see standard Title VII, which includes sex, race, religion, national origin, pregnancy discrimination still protected, Americans with Disabilities Act, GINA, which relates to genetic information, age discrimination, anyone over the age of 40, you need to provide, you can't discriminate against them based on their age. And the list goes on. You've got USERRA, protections for military folks. And so this just hopefully articulates to individuals, all this stuff should be things that you have in your policies, that you have in your handbooks still. This is still enforceable. And again, part of the reason that this injunction was issued is because a lot of, I think, companies are reading this and thinking, oh, I've got to stop all of this. And that's just simply not the case. It's just intentionally vague, which leads to a lot of confusion. There are also some, sorry, go ahead.
Right? No, I was going to say that was the court's whole point, is that in the injunction was that, like, how is anybody really supposed to comply with this? And it could raise some First Amendment issues. So that's what the court's juggling with, is the ambiguity and the First Amendment issues that could be implicated.
Mm-hmm. There are also a few state laws out there where this gets really complicated that do require certain types of affirmative action. whether it's related to contractors or other questions about what companies are doing to ensure that they have a diverse workforce. Jury's still out on how those interplay. Generally, an executive order can preempt state law, but only if it's a lawful executive order, which this one court has determined it is not. And so there are just a lot of questions out there. We would encourage you to reach out to your counsel if you are in a position where you need to choose between, your state law requirements and a federal contract requirement. But I'll also add that, again, this executive order does not prohibit sexual harassment training, for example. It does not prohibit investigations. And so there should be not a lot of clashes, but hopefully if there are, you have a resource you can rely on to navigate those weeds.
Yeah. And just a quick refresher, state law is not necessarily the state where you are, it's where the people are working, generally speaking. So that's important to keep it in mind because, if you're a multi-jurisdictional employer, which many government contractors are, you need to be compliant with several state laws. So don't forget about that. Okay, so we wanted to talk a little bit about VEVRA. We mentioned that OFCCP is basically gone. There's been talk about moving what's left of OFCCP underneath the EEOC. I think that's still in flux. So the question is, well, what's left if 11246 is gone? And what's left is protections for veterans and protections for the disabled. And we're going to talk about those on 2 separate slides. Those remain principally because those requirements are statutory and were not established by executive order. 11246 was established by executive order. VEVRA and Section 503 of the Rehabilitation Act are statutory, so they can't just throw them in the trash. The administration has said that they are going to hold the AAP requirements related to VEVRA and the Rehabilitation Act in abeyance. Nobody really knows what abeyance means, but what I take it to mean is that right now, while nobody's home at the OFCCP, they're not really going to be looking at them too much. That doesn't mean the requirement's not there. It just means that no one's going to be looking for the time being. We don't know when that turns back on. We don't know what it looks like when it turns back on. So I've been telling clients, like, look, if you're supposed to be doing your AAP for veterans or disabilities, do you have to do it tomorrow? Probably not. Should you assume you never have to do it? Probably not. You probably should get it done at some point. It's still a legal requirement. And so I just included a few slides on when VEVRA applies, and basically applies to qualifying veterans. You still have to have that affirmative action plan over 50 employees. It applies to contracts over 25,000, and you still have to fill out that VETS 4212. There's that annual reporting requirement that you still have to complete. So that's still alive and well. Sarah, do you want to cover this one?
Yeah, so, and I'll just say we've received a lot of questions, which is good. Thank you for participating. These are all great questions. We will respond to them as quickly as we can and as thoroughly as we can, if not now, but by the end. And if not, we'll get back to you in an email because we appreciate that there's a lot of confusion out there. There is, but focusing on the Rehabilitation Act, this obligation applies to individuals with disabilities. And so there is a similar obligation to have an affirmative action plan where contractors, again, have over 50 employees that evaluates your hiring practices with respect to individuals with disabilities. That has not gone away. There have been murmurs that some agencies are coming after individuals with disabilities next. We'll wait and see. We'll see where that's going. Again, this is statutory, so it's not as easy as just writing an executive order that gets rid of these obligations. So for the time being, those same obligations are going to continue. Again, Nichole mentioned OFCCP is sort of figuring out where they fit into all of this. So there's not going to be any enforcement action for the foreseeable future.
And the requirements track pretty much with the ADA. So if you're ADA compliant, other than the AAP and that kind of stuff, the requirements are very similar generally. All right. Let's move on to the next. This particular EO, I think, has been primarily completed. It was one of the first targets of DOJ, was to eliminate all DEI, DEIA, and environmental justice offices and positions, and all equity action plans. So this was, the DEI within the federal government has been growing for several years. There's a lot of DEI and training contracts out there. There are a lot of people within the government that are responsible for certain things related to DEI and equal employment opportunity. And DOJ has kind of gone through and gutted those things. This was also enjoined by that February 21 decision. But like USAID and like other big, efforts by the administration to change government, I would not be holding my breath and expecting these contracts to come back online very quickly, if at all. That's just my hunch on this one. I think maybe it's more than a hunch, but there's a lot of squabbling back and forth between. I think the latest I heard on this was that DOJ's position, maybe Sarah, it was you that was talking about this. I can't remember. I've talked to so many people about this stuff in the last few days. That the government's position is, even if they wanted to put this stuff back into place, they can't, because they've gutted everyone that could, right? So the defense to non-compliance with the injunction and the requirement to kind of put some of it back is that they don't have anybody to put it back in the bottle. So you can't require us to put it back in the bottle, because we can't put it back in the bottle because we fired everybody or they're on administrative leave and we can't bring them back. I don't know how that's going to play with a judge, but that's kind of some of the arguments that are floating around. So again, if you had a contract that was subject, that did some of this training or did some of this work, hopefully you get some of it back, but I have not seen like the USAID work come back online and things like that. So I'm not expecting to see a lot of it come back online. Which raises all sorts of other fun questions that are above the subject matter.
Yeah, we'll also say that the Trump administration has appealed the judge's decision. It's clear they're hoping for a different answer from someone else. So we're tracking that to see how that falls out. But yeah, unfortunately, not a lot of. I mean, there are some best practices, and we'll go over those at the towards the end of the webinar. There are also some myths floating out there that we'll debunk. But there's also a lot of gray area, and it's sort of just best preparing yourself based on a lot of sort of assumptions that we're making based on what's happened to date.
Yeah.
Yeah, so let's talk about the next executive order that ties in and that's really been implicating some of labor and employment practices. It's the Executive Order 14168, which is defending. It's another great title. It's a mouthful and it's confusing based on the words that are used, but we'll get into it. It's called Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. And really, it just boils down to the federal government has taken a hard stance against gender ideology, which is really just identifying based on the gender that you identify with, not based on the sex that you were born. And the executive order goes on and on about sort of the reasons why they're doing this, but ultimately it just boils down to the fact that they think that men who are born men should be men and women who are born women should be women, and that's the end of discussion. A lot of agencies have been implementing policies. You might have received some directives from your government customers instructing you to remove the pronouns from your email addresses. That's one thing that's been going on in the government. They're no longer including pronouns. It's not a contractor requirement, but to the extent that your employees have agency email addresses, they are enforcing this requirement across those email addresses. We've also seen this come up. There are a lot of trans employees out there who are working on federal contracts And there have been a few instances, I haven't seen it instigated by the government directly, but often there have been complaints that maybe a trans individual is using a restroom of their identity as opposed to the restroom of the sex that they were born as. And that has raised some complaints. And we've seen agencies following through and saying, you can't let this employee use this restroom anymore. Which has been obviously upsetting for a lot of the trans employees out there. What we've been counseling employees on is, or sorry, contractors on, is that they talk to the employees, see if there are opportunities for like a private restroom, see if there are other ways that they can, maintain their privacy without running afoul of the agency. But unfortunately, we don't have a lot to push back on at this point, given the speed with which agencies are, or DOJ really is canceling contracts.
Yeah, just keeping in mind that state laws still protect, in many respects, gender identity, not all states, right? And sexual orientation. And federal law arguably protects sexual orientation. So just keep in mind that even though the government is requiring some of this and there's not a lot of ways to push back, there are some steps you might want to try to protect yourself if you're a contractor in order to avoid some of those, claims under either federal discrimination laws or state anti-discrimination laws. Like, we want to make sure that as a contractor, we've taken appropriate steps in order to mitigate any risk of litigation.
I need to make a huge apology to the group. Somehow OPM got changed to OMB. These are not OMB memos. These are OPM memos. I knew it. I saw it and I was like, what did I do? So I apologize, everyone. Those are OPM memos. The links are there. I don't know what happened with the spell check, but just putting that out there. There has been an OPM memo issued on this defending women. It pretty much echoes the executive order's language and just emphasizes that gender identity be removed pretty much from every facet. Also, fun fact, the EEOC is no longer enforcing gender identity cases. So I don't know what's going to happen to the current cases they've got on their docket. They're probably just going to withdraw. But just keep that in mind. It doesn't mean, again, Nichole mentioned that there are state law requirements. The Supreme Court has issued a case that essentially says that gender identity is the equivalent to sex, and you can't discriminate based on sex. Therefore, you can't discriminate based on gender identity. So that law is still out there. It's just that the administration is taking the position that they don't consider it to be a protected class.
Yeah, and I think they have something in the EO itself, or some of the documentation that basically says they disagree with prior administration's interpretation of that case. So that will get.
It's pretty blatant. So it's hard. I don't know.
Yeah.
The case does not mince words. Someone asked if you have to remove your pronouns from your emails. It is not required, but my caveat is a lot of agencies are also confused about what all these EOs mean, and it is possible that you will get, correspondence from an agency or from DOJ that views this differently. But at least under the EOs as they are drafted, there is no requirement to change your pronouns.
Yeah, and I do think you need to pay attention to, do you have contractors that are working at agencies that have that agency's name on that email, as opposed to your email with your company's name, right? So I think the government has a better argument that you cannot use pronouns if you are using a signature block that says that this employee works for the National Institutes of Health, right? So just pay attention. And a lot of contractor employees have, their government email and their, work email. So I do, there has been some of that as well. Like, well, your signature line says NIH on it. So whatever it is, right? Mm-hmm. Whatever, insert agency.
We had another question that asked what's DEIA, just quickly: diversity, equity, inclusion, and accessibility. So it's dealing with those individuals with disability accessibility questions.
Okay, so let's walk through just a couple of myths. And I think we had a question about this as well. We get this question probably a couple times a day. Are set aside programs made unlawful under the new EO requirements? No, they're not. And clients will call and say, but like, aren't they coming after us? There's not an indication right now that they're coming after these set aside programs like WOSB programs, 8A, HubZone, SDVOSB, and the like. I will say that if the number of SB clearly has come out, the new administrator has come out and said, we're not increasing the threshold beyond the statutory threshold. And I think there is something up on the website right now that basically says like, hey, we believe that if we increase the threshold past the statutory threshold, that we are actually discriminating against other groups of people. So you do see kind of flavors of this dovetail into certain SBA policy, but the programs are not gone. The statutory thresholds are still there. Obviously, if the number of contracts decreases, that impacts the amount of dollars going to set aside programs. And of course, folks in the government have to utilize these programs. So I think there's going to have to be some more, advocacy as to, kind of leading contracting offices to the water and having them take advantage of the programs, even though there's not as much of a push.
Another myth that we've been seeing, we touched on this already, but it's always a good reminder. All DEI programs are now illegal. That's not true. The executive order is very specific. If you read it, if you have the pleasure of reading it, at no point does it say that DEI is illegal. I think the administration realized that was a bridge too far, but it's specific to illegal DEI. Again, the question is, what exactly is illegal DEI? There's an argument that affirmative action itself isn't illegal. It is encompassed within a lot of the laws that we've been talking about. But the question out there that remains is what the agencies and what the administration believes to be illegal DEI. We've heard stories of agencies saying, and this is not true, but we've heard stories of agencies trying to say you can't celebrate MLK Day or you can't appreciate historical figures. That's not what we're talking about here. But there is a lot of confusion about this. What we've been advising folks is, to the extent that you've got like affirmative action obligations, probably best to roll those back to comply with what we think is going on here. To the extent that you've got DEI programs, maybe you want to think about how you're marketing those, what you're really focusing on, take a closer look. But we'll go over some practices you can take for the time being when it comes to reviewing your policies and procedures that will comply with the requirements of the executive order without going too far such that you're compromising your EEO obligations.
Yeah, so another myth is contractors can no longer ask employees, applicants to self-identify their reasons, sex. This is a myth. Again, if you're over 100 employees, you are going to need to do this in order to complete your EEO-1. So if you are tracking, you might not need to track some applicant data anymore, at least for sex and minorities, right? But as far as your employee demographics, you can still track numbers as long as you're not using that information to implement a hiring preference. Right? So that's really what we're concerned about. We don't want to implement hiring preferences. Frankly, we never wanted to implement hiring preferences based on that information. That was never a good idea. If you'd called me 6 months ago, I would have told you that's not a good idea. But can it be used to just kind of understand what your demographics are, to use it for EEO-1 reporting? That is fine.
We got a question that kind of ties into some of these issues. The question is like, how is DOJ going to know, or how is the agency going to know if you hired someone based on their minority status or based on, legal permissible reasons? And the answer is basically, it's like this whole series of case law for enforcing Title VII. Already, it's illegal to hire someone or not hire someone based on their sex, or based on their race. That's already out there. And there are a number of legal kind of processes that you can go through to evaluate whether someone was hired. You've got timing, you've got comments, you've got direct evidence. But generally that's not something that the agency is going to get into. I suppose they could, but really they're focusing on your policies at this point. So
Yeah.
do your
What's out
policies
there
and
online,
procedures.
what you have
Yeah.
on LinkedIn, you know. But I
Yeah.
will say that as we get further down the line, this is another whistleblower issue. That's how I think this is mostly going to come up, right? Or they ask you to confirm that you don't have any of these. That's going to be if they are allowed to put the certification information back on the certification requirement back online at some point. And then you have internal whistleblowers, right? So you make an employee angry and they, report to an IG or go to a plaintiff's lawyer and become a relator under a key tam action that you are violating a material term of your contract as a result of impermissible hiring practices. And I had a case like this a couple of years ago relating to someone within a company that alleged that the company was engaged in illegal hiring practices. And so this does come up. This is going to give that went to the EEOC, but this is going to be another layer to that. So I think that's how this is going to really come out, just like a lot of other certification requirements. It's enforced through whistleblowers.
Yeah, for sure. And
Yeah.
that's just this myth number 4, which is that contractors should immediately delete their equal employment opportunity policies from their websites, handbooks, and job postings. No, you need those. Those are still around. Those are permissible. Don't get rid of them. They're actually even more important if this certification does go into play.
You might
Nichole,
look at the language, though, like double check the language, because some people have affirmative action language in their EEO policies because of AAP requirements and OFCCP requirements. So it's worth taking a look at that language and making sure it doesn't raise any red flags. Sorry, Sarah.
agreed. I was just going to say we got a question asking about this EEO1 report. And I just wanted to clarify. So under Title VII, there are additional obligations for companies with at least 100 employees to comply with those self-identification obligations and to create that EEO1 report. Those still apply. What's changed is federal contractors, there was a lower threshold. If you had at least 50 employees, you had an obligation to go through those same processes. But this executive order has removed that obligation. So you no longer have the obligation to self-identify employees and report. So yeah.
At 50, but at 100, you will. So it's
Yep.
important that it's just a different threshold. That's all it is. Okay, so let's talk about, we've talked about a lot of this throughout the webinar, but we kind of wanted to put it in one place. Things that we are, talking with our clients about. The firm is, a lot of times, companies will have affirmative action policies in their handbooks or their codes of ethics. We might want to, because of this language, this around affirmative action and people being very sensitive to that language right now, you may want to consider changing that to VEVRA and Rehabilitation Act compliance and adding language that basically says, we understand our obligations with respect to VEVRA and the Rehabilitation Act. And there is, a requirement to notify employees that there's, we take affirmative action and we have an affirmative action plan. So you want to think about that language and try to revise that language a little bit so it's not as broad as you have it if you have an affirmative action policy. You might want to revise your approach to applicant tracking and self-identification depending on the number of employees you have. Remember what Sarah just talked about, the EEO1. The EEO1 generally is tracking current employees. And so you might have to maintain some applicant tracking for, veterans and disabilities, but you may not have to do that for other folks. Again, I don't really expect to get like robust regulations around this stuff. So we're taking kind of recommended actions based on what we think is out there, and as it evolves, we'll try to put out information as soon as we know. You might want to review your recruiting processes. Apologies about the typo. There's a little typo there. Recruiting processes to ensure there's no quotas or preferences. So in the memorandum that Sarah referred to earlier, that talks about what an illegal DEI program is. There is a reference to recruiting and kind of populating the interview pool with certain numbers of people in different demographics. That kind of thing could be considered illegal DEI. But simply recruiting in lots of different places to get a robust applicant pool, that's not illegal DEI, right? So you might want to be reviewing how you handle your recruiting processes to make sure you don't have any quotas or preferences built in. Again, anything that affects terms and conditions of employment. I bet a lot of you haven't looked at your handbooks with respect to your discrimination, harassment policies, reporting policies. Good time to look at those and see what's in there, right? I think we just copy paste a lot, from handbook to handbook, and we don't really look, but it's a good time to take a look at it and make sure there aren't any red flag items in there. We talked about the EEO statement. Make sure you're compliant with state laws, updating the subcontract language to take out those references to 11246. Take a look at your website content, including your LinkedIn page. I have heard from several folks within government that DOJ is using AI to check websites of government contractors for any reference to diversity, equity, and inclusion. So I'm not trying to be a scaremonger. I don't think that a lot of what's on employers' websites are actually illegal DEI, but I also don't really think DOJ knows what that means. So in a lot of cases. So, take a look at it and you can make a business decision as to what you're comfortable with there. Don't forget your LinkedIn content. Take a look at that. And evaluate your procedures for complaints, right? We want those whistleblowers to come to us first, not to an IG, not to someone else, not to a plaintiff's lawyer. We want them to come to us first. Sarah, you have anything to add there?
No, I'll just say we've gotten a few questions about FAR clauses and whether companies or contractors should proactively be taking those out. I actually don't know what your answer is on this, Nichole, so maybe this is good we're having this conversation.
I would not take them out proactively. I would take there's a reference in your subcontracts, or in your subcontracts there should be a specific, not the FAR clause, but a specific equal employment opportunity clause that relates to 11246. That I think you could take out now, or you could wait for the FAR DB. We could wait a little bit there, but that I would take out. The FAR clause itself, if it's in your prime contract and it's required to be floated, I'd wait until you get that FAR deviation and that contract modification. Now, do I think there are really any real consequences for taking it out? No, I don't. But you don't want to make a mistake and take the wrong one out and take VEVR out, or you want to make sure that you get it right. I think there's probably very little real consequence for taking it out if you do, but I also, think that it's totally fine if you leave it in until you get a deviation.
Yeah. And there have been, GSA issued some deviations that took out FAR clauses. I don't know where that sits now with the injunction. I think it's been paused. But yeah, agencies have started thinking about this. They should also be revising the representations and certifications to take out the reference to, because if you guys have AAPs, you likely are familiar with one of the certifications, which is like you promise that you are compliant with the AAP obligations. Those should be coming out and should no longer be applicable on a go-forward basis. Okay, so that brings us to sort of the wrap up, I guess, of what we've been talking about. And we do see there are a bunch of questions. We've got a little bit of time, so we'll try to go over a lot of those as well. But just like best practices, how to stay out of trouble with your contracts, hopefully. And I'll just add, we are familiar with the fact that a lot of contracts are being terminated for convenience right now. And so there are other conflicting interests going on right now. There's a lot going on, and we're just really focusing on this executive order, but I don't want to ignore the fact that there's some other moving, competing forces at play. But at least with respect to this, you want to make sure that you have robust EEO policies. I cannot stress that enough. This executive order does not get rid of those obligations. You have robust EEO policies. You have open door policies to make sure that employees are coming to you if they have complaints or concerns. You want to make sure that you have a good investigative process for looking into complaints of discrimination or harassment. And generally just have that process down, because you still are obligated as a company, as an employer, to pursue those types of investigations. You want to stay up to date on your contract requirements. It's just really important. If there are any modifications or deviations that are issued that should be sent to you, you want to make sure that you're paying attention to what those are. If you are going to be signing any certifications, don't do so lightly. Make sure the language in there is right. Make sure it's appropriate. And again, if any prime contractors or agencies start asking you to sign these certifications, I would push back for the time being. The court injunction should have put a stop to that. You also want to ask those questions proactively. I mean, be respectful. I don't know that I would necessarily encourage a client to push back to the extent that your contract is at risk, but just be wary that where we are in the state of things. And then lastly, I'll just emphasize that VEVRA and Rehabilitation Act AAPs are still permissible, are still around, are still required legally. So you don't want to strip out everything without including those carve-outs.
So, and with that, we can go to a couple questions. One of the questions that kind of came up early on, sorry you're getting a black screen right now. Sorry about that.
If it was my computer, Nichole, we'd see like a million different documents. So this is better.
I'm just gonna turn this, just go straight to, anyway, while I am messing around with my computer here, one of the, there we go. That's what I was trying to do. Stop sharing. Took me a minute. So one of the earlier questions are those pre-award approvals gone under the EEO? I think they're pretty much gone, right? Like a lot of the pre-award evaluation was about OFCCP compliance and 11246. Again, VEVRA and the Rehabilitation Act are still around. So could there still be a pre-award evaluation with respect to compliance on that? Yes. Could there be a pre-award evaluation with respect to your compliance with this executive order generally, and that you don't maintain any illegal DEI programs? That could come about. We haven't seen any indication of what that might look like yet, but so I think that's an evolving issue right now. But I definitely think if the contracting offices wanted to, they could do the VEVRA and Rehabilitation Act evaluation under that pre-award compliance obligation.
We've also got a question about whether language related to sexual orientation and gender identity should come out of your EEO policies. My approach has been, it doesn't have to. It's no longer required. Previously, there was an executive order that was put in place by the Obama administration that required essentially that you acknowledge sexual orientation and gender identity, but it's no longer a requirement. I don't think there's anything in these executive orders that prohibits you from having that in that EEO policy, but it's not necessarily a requirement, and arguably it's already addressed by sex under the Bostic decision out of the Supreme Court. So I guess that's sort of a lawyer answer. There are a lot of sort of permutations of how you can approach it, but it's not a requirement.
Okay. I'm just going through here. If you see one before I do.
I've got one that talks about grant awards. I want to make sure that I'm getting the full spirit of it. There are some funds that have been terminated for grant awards based on, being not compliant with the third executive order that we talked about. This applies to government funding really broadly. So grant awards do unfortunately get caught in the crossfire. And at this point, I mean, there could be some arguments you can push back on this type of action now with the executive order, but we haven't seen a lot of traction.
Yeah, and there are some cases pending. You saw this with like some of the USAID litigation about, can the government really pull back obligated grant funds? We'll see how those kind of flesh out. I do think there's some different legal considerations, but the way that the administration is taking the stance, it applies to those funds as well. We got a question about why wasn't affirmative action based on race and gender ever codified and made law? Why was it only an executive order? It was codified and made law. That's the Civil Rights Act. That's Title VII. But the executive order went further than Title VII in that it required these affirmative action plans, and it provided federal contractor employees a place to complain other than the EEOC. And it provided for this investigation by the OFCCP. And over the years, kind of what OFCCP did expanded. So it was codified. Like many laws, executive orders predate the actual law, right? So that's kind of how that, but again, Title VII is still out there. You can't discriminate against people on the basis of race or sex. It's just that 11246 went away. That's all. Kind of this like additional government arm that applies more to government contractors has kind of gone away.
Mm-hmm. Got another question. I'm sort of cheating by starting at the bottom, so apologies, but it was right in front of me, and it's a quick one. Question of whether we recommend that sexual orientation and gender identity be removed from a CBA in federal contracts. First of all, I'll just add sexual orientation it's not a requirement, but it hasn't faced the same onslaught that gender identity has been. So I don't think there's the same level of concern with including sexual orientation in your EO policies. Gender identity is a little wonky because under a CBA, at least if it's an SCA contract, that ultimately can become your wage determination, gets incorporated into the contract. I could see a overly concerned agency saying we're not going to include this because it has gender identity in it. It might be just another consideration. I don't have the absolute answer here, but I think it could be an issue that you might want to get ahead of with your union.
Yeah. Couple of things. Adverse impact analysis to make sure we're not discriminating against anyone. That's, in my mind, still fine as long as we're using it to just confirm that we don't have disparate impact issues. That's the same way I feel about pay equity analysis. Before pay transparency was like an issue with it, when the Biden, I think it was the Biden administration? Obama? I can't remember which administration did the EO on pay transparency. The years are running together. Okay, it was like, who did that? I know we got final rules we got some rules during the Biden administration. In any case, those pay equity analyses were still a good idea even before we had that, to make sure we don't have systematic disparate impact issues with respect to pay in the workplace. So yeah, that's not setting quotas for hiring. That's not stacking the deck. The other question we got was, can we still seek diverse candidate slates? Yes, as long as when you go into like the interview process, you're not saying we need 10 women and 10 men. So you seek really diverse, broad pools of applicants, but then once they come and clear through your minimum requirements system, it's kind of whoever meets the criteria. I think if you said, I need equal numbers of men and women, that might be an issue under this executive order. Would you agree with that, Sarah?
Yeah, I do. And I would also avoid, often when you're seeking a diverse slate, that means you're also targeting certain groups in order to make sure that it's diverse. But under this executive order, I wouldn't necessarily recommend that. You just got to be a little bit careful in how you roll it out.
But if you're seeking, applications from 5 or 6 different places and you're just trying to get lots of different kinds of people, that's fine, I think. But again, important to look at what you're actually doing and how you're pulling candidates and what the criteria is as well. And I think
HRCI credit.
And we did have another question about like, what about veterans and people with disabilities? If you join late, the VEVRA and the Rehabilitation Act are still there. They're statutory. Those requirements have not gone away. We had a request to talk briefly about the injunction. The crux of the injunction was that the judge found, it was brought by several different trade groups, but a judge found that basically the term illegal DEI was too broad. And so you can't make contractors certify. You can't have the AG investigate private companies for illegal DEI when they don't know what it is. And you have to stop like just blanket terminations of DEI type contracts for the time being, because we think it could be a First Amendment issue and we think that it's overly broad. I think that's basically the crux of it. Again, that decision is under appeal. If you have these contracts that might have been terminated, again, I'm not holding my breath. They come online anytime soon, but you know, maybe it'll surprise me. I think we covered almost everything, Sarah. I think we did okay. If you have other questions, please feel free to reach out for us. I know we're one past the hour. We want to be respectful of everybody's time. No, this is a treat for us to get out from behind our email and actually talk to people. So if we didn't get to your question, we'll try to kind of filter through and email you back, but we really appreciate you spending your hour with us.
Everyone.